debt collector lawsuits, when you get that summons at your house, you get that knock on the door, and that individual is saying you are being summoned to court for a debt collection, or maybe they don't know that information, even though it's not closed, so they don't know who's suing you. But you open that up, or you look at that paper and it says debt collector suing you in court. Well, let me tell you one of the strategies that debt collectors are using. I want to raise your level of awareness about how these debt collectors are not actually filing court cases. Now, not to say that they're not intending to file a court case, but this is something that they're using to kind of trick people into paying without even having the opportunity to have a day in court, having an opportunity to be able to respond to the court summons, to not even have the opportunity to win the case, because they're using this strategy because of what happened during the national shutdown that we had. Debt collectors had figured out a way, because we were in our homes or in our offices and we were keeping ourselves away from each other. They said, oh, you to upload that court summons onto the court website, and you don't have to pay for it until you're ready to actually file the case. Well, the debt collectors, to doing that, someone in their office must have said, hey, when it's coming from the court, it'll look like it has more credibility that the individual is being sued, and they're more than likely to contact our office and try to do something about this, and we don't even have to come up with the money to actually file the case. We could just pay the process server $50, $60 to serve it and save the money and have people get afraid and just call us about the debt. So let me tell you about two situations that happened. I'm going to tell you about a woman who won her case, and she gave us a call yesterday, and I'm going to tell you how the debt collector tried to trick her into losing her case. And also the court was kind of wavery on this, but she ended up getting it dismissed. And I'm going to walk you through exactly what she did and how they were trying to trick her. Not the court, the debt collector. And then I'm going to tell you about a fake case. And I'm going to walk you through how these debt collectors are using this strategy, because the courts make it available with the uploading of documents without having to pay for the case. How this is working for them in their favor, to be able to scare people into paying for debts when they didn't even give themselves a chance to even respond and fight to the case. So, like this video, subscribe to the channel. This is good stuff that I'm giving you. This is real life stuff that I'm giving you about how debt collectors are utilizing the court systems without even actually filing a court case. But you have to be prepared. If you're prepared, you're going to put yourself in the best position to win these debt collection lawsuit cases. So first, let's start with number one. Client comes to us. They're getting sued by a debt collector. How do they know they're being sued by a debt collector? Because debt collector sent them a summons and it was served at their house. So they know that there's a court summons. But from reviewing it, when we reviewed it, we noticed that there was actually no court case on there. Now, because a lot of this stuff is done and no employee is perfect. No employee is perfect. Even the debt collectors, their employees are not perfect. And so the documents could be put together and filed with the court, and the court case number was just not put on there for whatever reason. That has happened before. So we always tell our clients, you get your response prepared and you go down there and you file it with the court, unless it's required that you upload it. But no matter what, you're going to file it with the court. So she did exactly what we told her to do. She went down there. The court clerk said that there is no case filed. She called us back up. She said, what should she do? And we said, what you do is you keep calling to find out if, later they might file it. She asked the court clerk what to do. Court clerk said same thing we said. Keep calling every few days. It'll probably get updated and filed. Remember, they're not just dealing with you. It's not just you. So she followed that. She followed that for a full month. They never filed the case. Month later, little more than a month later, all of a sudden they send her this letter saying motion for summary judgment because she didn't respond to the court summons. And so she called us up and she said, what should I do about this? I did respond to them. And I said that, number one, first call down to the court to see if they did file a motion for summary judgment. But let me just tell you, this is all smoke and mirrors on what they're doing. But you have to follow the steps or you're going to get yourself caught up. So follow me. They had her served with a court summons. She got her court summons response prepared by us. She submitted that to the court. They said there is no case. You can't file a response when there's no case filed against you. We said, hold it. Keep calling. Maybe they'll update later. The clerk at the court said, just keep following up. Call us. We'll tell you if it's been filed. Some of the times they have the websites where you can look it up for free. Never filed. The original summons was never filed. More than a month later, they send her a letter saying motion for summary judgment because you didn't respond to the court summons. Well, there's no court summons to respond to when you didn't file it with the court. There is no court summons to respond to when you didn't file it with the court. Now, if they're talking about you should have responded to us, well, still the proper way when you respond to a court summons is to respond to the court summons with the court, and then they get a copy to you, or we get a copy to you from that court. But it has to be filed with both parties. But because you never filed a court case with the court, there is no court summons for me to respond to or for her to respond to. But what they were trying to trick her into doing, this is the trick. The trick is not to have a court summons actually filed. The trick is to get the individual to get afraid and to have them call about the case. Because the first thing that they did, which is what she actually did, and I said, don't worry about that. You did the right thing to call them. But the first thing they said is what you're going to do to resolve this matter. That is the trick that they're trying to do. They want the person to get scared and to respond that way. So she did not fail to respond to the court summons. There was no court summons to respond to. Now they're doing the motion for summary judgment, and she's going to call down there, and you can't have a motion for summary judgment when you did not file the original summons. How can you say that she didn't respond when there was no legal way for her to respond to the court summons, the original court summons? So let's talk about how this client could end up getting what I believe is $2,000 payout for violation of the Fair Debt Collectors Practices Act, where debt collector is threatening. And I'm going to get the actual line in the Fair Debt Collectors Practices Act. Okay, so according to the Fair Debt Collectors Practices Act, Section 807, false or misleading representation. And we're going to go down to number 5. So it would be 807-5. 807-5. The threat to take any action that cannot legally be taken or that is not intended to be taken. So you might be saying, well, Steve, if they threatened to take me to court, they filled out the documents, they didn't actually file it with the court, and then I say back to them, you just made a threat that you didn't intend to follow through on, wouldn't they go ahead and follow through on it? Well, wait, let's back up. What did they do in this specific case? That's why you want to always pay attention to where you're at, because what they actually did to her, and she's very lucky to be one of our clients, is that they got her emotionally attached to what they were doing and made her forget about what she had actually done in advance. And then she calmed herself down, and she said, wait, I did do what was required, but it was not actually filed with the court. So section 807, that is in number 5, line 5, paragraph 5, the threat to take action that cannot be legally taken, which would be for a debt that is past the legal statute of limitations, or for a debt that they don't actually own, and or that is not intended to be taken, which is they did not intend to really file the case. Where we have them right now is that the initial court summons that they said that they filed, that they did not file, that did not have a case number, they did not intend to file that. It doesn't matter. They're already trapped with that one. So that's $1,000 right there for that violation. Number 2, if there is no motion for summary judgment that is filed, that's going to be violation number 2, because the lady on the phone, the rep on the phone with the debt collection company, stated that the motion was filed. And remember, they record all conversations, so they know when this is sent to them. Once we get all of the information is sent to them, I believe that they're just going to pay out the $2,000 on that violation, potentially $3,000, because some other things are coming to mind that could be violations. So before I move forward to the other case that ended up being a dismissal yesterday, let me just review. They said that it was a court summons. They gave her the court summons. She was served. But when she got a response done by our company, took it to the courthouse, they said there is no court case that is filed. Some of the times, the case number is, they forget to put it on there. Workers are not perfect. Employees are not perfect. So sometimes it has been forgotten to be placed on there. All documents can be there and someone just forgot to put the case number on there, because they got to get that case number from somewhere else. They don't just generate it themselves. So they forgot to put it on there. And if it's on there and you get down there, you can just write it in. They don't have to, it doesn't have to be typed in. You'll see even with attorneys where it was written in. You'll be like, they typed out everything else and then this was written in with a pen. They can do that. When she got down there, they said it was not filed. She called us. We said, what you got to do is just keep calling, because it could get filed later. Even the court clerk, someone that's not even involved with our company or with her, they just said, hey, this stuff happens all the time. Just keep calling, and if it gets updated, you'll know so you can file it. But you can't file it if there's no court case. There's nothing to file your response on. She had it in her hand. There is nothing that you can file your response on if there's no court case filed. And you have a responsibility to respond to the court and to the debt collector. But if they don't file the case, there's no need to respond to the debt collector, because you're not, only thing that you could respond to them on is a dunning letter and do a debt validation, and to make them, prove everything with the documents that they have saying that you owe the debt. That's where you would be at with them. So now let's continue on. That you got that. If you didn't get it, rewind this video and listen, watch it again, because this stuff is very important. And if you haven't done it yet, like this video. If you have not done it yet, like this video, because this is stuff that is being used against people like you. And if you don't know, how to maneuver your way through it, it's going to end up making it to where you can accidentally have to pay a debt collection that you don't have to pay. So you have rights, but if you don't know how to initiate your rights in the step-by-step process, they're going to look at you at every step, and you're going to be like, I'm doing everything right, but you're not doing it in the right order. So there is doing things right, but there's also doing it in the right order. And that's where I see a lot of people get mixed up. They get upset, they get frustrated. They're like, I'm doing all of this stuff the right way, but what you're not paying attention to is you're not doing it in the right order. And that debt collector is trying to get the person to have to pay for a case by tricking them, hoping that they don't know the right order. So now let's look at the next thing here. Is yesterday a woman called and she said that she went to court, and soon as she walked in for her case, that they were trying to get her right away to start to try to work out a deal on the case. Like, don't go into court and don't worry about, talking about your response. Let's just talk about what you want to do. Let's just go into this other room. So she said, I'll go into the other room, but in her mind, what she was thinking about only was, I'm going to tell the debt collector, I don't owe you. What about my response? So she goes into there and they start talking, and debt collector said, how you want to pay this? She said, I want to talk about your response, get me all this documentation. And she just read like what we prepared. She just read like, give me this, all of the stuff that we tell people to ask for. Debt collector said, well, we don't have that. Why don't we just come to a resolution? We don't have all of that stuff. I'm going to need more time to get that stuff. She said, well, I've given you plenty of time. I got this to you, almost right after you sent the summons to me. So no resolution came. Said, okay, let's just go back out there. I had a judge call us up, and I'm just going to ask the judge for more time. They get her time to come up. She also threw in that other people were going through all of this stuff, and they were just getting default judgments left and right. Didn't even have no answer to anything. And she said, one lady, check this out. Let me tell you something. One lady heard her situation and just used one thing that we've told our clients to do, and her case got dismissed. Just use one thing, ask for one document that she was like, I'm just gonna throw it out there. Do they even have this document? And the debt collector dismissed that lady's case. So off of just the information from what the lady heard from what we told the other lady to ask for in her response, just using one of those items got her case thrown out. So lucky, good, congratulations to her. So what she did, so they said, okay, the judge said, okay, let's call everybody back up. And what did y'all work out? The judge said, what did y'all work out? He said, we didn't work out anything. I want to, the plaintiff attorney said, I need more time to get some stuff that she had in her response. Judge said, why don't y'all just work out something? She's talking to our client. She said, no, I just want to get this stuff here. Judge said, okay, I'm going to give them more time to respond to the court summons. So she said that they were typing up everything. They were doing whatever they do, getting another court hearing date, all of that stuff. And our client said she just sat back and just waited. Like, just sat back and waited, because that they're going to still ask the defendant, do you have any questions? And she did exactly what we instructed her to do. So when the judge asked her, does she have any questions? She said, yes, I don't want there to be another hearing. I object to another hearing. And judge said, why? Because I gave them this response and they've had plenty of time, weeks, to get this information. And I want this heard. And the judge said, okay, we getting ready to hear this case. First question the judge said to them is like, where is all of this stuff? You've had plenty of time. You've had plenty of time to get this information that the defendant is requesting. And they said, we don't have it. So our client said, okay, I want a motion to get the case dismissed. And the judge said, if you don't have it, you've had, to the plaintiff attorney, you've had plenty of time, you don't have it, case dismissed. So here is the thing, and this is a trick that they do, and I've even seen this happen where they try to spread this out over a year because they want people to forget. So what they'll do is you respond to the court summons appropriately. If you use our company, you're going to really give yourself a huge chance of winning your case. When they get that response, they know that they usually can't get all of those documents. Not to say that they can't, but in most cases they can't. So what they try to do is they just try to delay. They started contacting the person that they're trying to sue to try to see if they can work out a deal. You still have a right to make them prove everything about the case, the amount, all of that stuff. But if it's up to you on how far you want to take it. This client said she wanted to take it all the way to get a decision, and obviously the decision worked in her favor. And she kind of started knowing from some signals that the plaintiff attorney was giving her that they just couldn't get the documents. So you have a right to make them get all of that information. And if they tried to delay it, this is what we've told our clients to do. If you want to push it, is that you put in a motion to have it dismissed. After a certain period of time, if they don't have the documents, they're not going to get the documents, and you can motion to have it dismissed. If you're in court and you did get your response into them with a good enough time, at least more than a week or more, that they've had to be able to get those documents, they're not going to be able to get them if they don't get them. You can tell the judge that you object to having another hearing and that you want, if they need to hear the case right at that time, they can hear it, or the judge could just dismiss it and tell them to come back at another time. Most of the time they will not come back because they're like, we're going to just run into the same problem. All right. So if you need help with a court summons, there's a link below this video. You can go to my website, put that summons on our live chat. We'll review it, let you know how we can help you. If you have a motion for summary judgment, post that up there and we can let you know how we can help you. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process, that's the way that we repair credit, and we can help you repair your credit and increase your scores using that process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters: statute of limitations, debt validation, and cease and desist collection activities letter. That will help you stop debt collectors early in the game, or prepare you for if a debt collector tries to take you to court, because you'll be able to see what documentation they have to prove that they can come after you for that debt. Thank you for your time. Please subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.